I seek your Lordship's indulgence in mentioning Part 2, Item number 5, Your Lordship, of the hearing list. Your Lordship.
Part 2, item number
5, Your Lordship.
5.
Yes, Your Lordship. I have taken the consent of the opposing party, Your Lordship, if this matter may be listed again after, Your Lordship, on the 5th of February, Your Lordship.
What is your name?
Miss London Louis. 5th of February, Thursday.
You are government advocate.
Yes, Your Lordship.
Okay. Then we are passing no orders. We'll take it up on 5th.
Yes, Your Lordship. Much obliged, Your Lordship.
My Lord, I beg to mention item 8 from part 2. This is RFA 12 of 2023. It's a consensus prayer. If it may come up on 11th of February next week.
Okay. Heard Mr. C. Tlang Thiang Lima, Learned Counsel for the appellant, who prays for listing this matter on 11th of February. Miss, what is your name?
Miss Rosie.
Miss Rosie, Learned Counsel for the respondent, does not raise any objection, hence the prayer is allowed. Let this matter be listed on 11th February.
Obliged.
My Lords, if I may also mention Part 2, Item 13, my Lords. It is a appeal from conviction, jail appeal. My Lords, if this may be listed on 9th, my Lords, of February. I have spoken to the Legal Aid Council and Council for the State, my Lords.
9th is in next week. Okay. Heard Mr. Jordan Roaming Thanga, Learned Amicus Curie,
Yes.
appearing for the appellant, who prays for listing this matter on 9th of February. He submits that he has obtained the consent of Learned Counsel for the respondent side, who does not have any objection to same. The prayer is therefore allowed. List accordingly.
Obliged.
Daily list for admission, item 1.
My Lord, in this matter, there's one IA. IA number 4 of 2026. This IA is for, my Lord, impleasement of the new incumbent as respondent number 8, 9, and 10, my Lord.
Who is for the respondent side?
The respondent has been, counsel is, my Lord, H. Gupta, my Lord, H. Gupta, from Guwahati. This matter has been taken up by H. Gupta, my Lord.
They are new incumbents.
Yes, my Lord.
Okay. We are allowing this prayer.
Yes, my Lord.
Heard Mr. What is your name?
H. Zaudin Sanga.
H. Zoding Sangha, Learned Counsel for the applicant. This application under Order 1, Rule 10 within bracket 2 of the CPC, read with Section 151 of the said code, has been filed by the applicants for impleading Mr. Anjani Kumar, Chief Administrative Officer / Construction 2 Northeastern Frontier Railway, number 2 Mr. A.K. Mishra, Chief Engineer Construction 2 Northeast Frontier Railway, and Mr. Arvind Kumar Meena, Deputy Chief Engineer, CON-ISL, in as respondent number
8, 9, and 10, my Lord.
8, 9 and 10, as they are the new incumbent why you are praying for it their impleadment?
My Lord,
Why this prayer is made?
since it has been replaced, the previous incumbent has been replaced, my Lord.
Who were the earlier incumbents?
Earlier incumbent is respondent number 3, 4, and 7, my Lord.
They are the new incumbent to the post which were earlier held by respondent number 3,
4 and 7.
4 and 7. Stop. Considering the submissions made by learned counsel for the petitioner applicant, the prayer is allowed. The aforesaid incumbents, aforesaid persons may be impleaded as respondent number 8, 9 and 10 in the connected contempt case. The applicant is directed to submit corrected cause title in the connected contempt case within a week from the date of this order. This interlocutory application is accordingly disposed of. List the connected contempt case after a week on a date to be fixed by registry.
It's okay.
Item numbers 2 to 5.
My Lordship, I'm being led by senior counsel from Delhi Lordship in these Mahindra matters. So now I receive instruction that it may kindly be adjourned to 30th of March, Lordship,
Why?
because I have no instruction to take up for hearing, my Lord. I'm being led by senior counsel from Delhi Lordship, Mr. Naresh Kaushik.
What is the matter in these cases? Cancellation of bail.
Cancellation of bail and some of the petitions.
You are for?
Mahindra, my Lord. Mahindra.
Who is for the state?
My lords, for the state, I believe.
This is
Whether
being-
state is opposing the grant of bail?
My lords, can I say? My lords,
Yes.
similar petitions have already been disposed of.
Yes,
My
there
lords,
is
the-
no.
There is no challenge from the state.
And there is no
Violation
no
of
way
law.
we can keep these matters pending for such a long time.
Yes.
Who are you?
I am the victim, my lord. The victim in the scam.
The charge sheet has been laid.
Just with had already been now he has filed.
Trial is ongoing.
Trial
Trial is going on.
is going on right now.
You are facing the trial.
Facing the trial, my lords, I've been appearing. Not only me, my lords, all the co-accused have been duly appearing before the learned.
Then what is the reason for?
Due to non-consideration of the materials in the and circumstances.
No,
of
we
the
cannot
case.
keep these matters pending for long.
So I think for that, my lord, we have to take it for disposal on the next day, my lord.
Next,
Next day, yes, lordship.
when?
March, my lord.
Why March?
Because on that day, my lord, the council, the leading council will be available here.
No, should we always fix cases as per the availability of the council or the court cause list?
That
You,
depends.
you
my lord.
have taken, your
Yes,
leading
definitely.
council has taken it for granted that whenever they will pray for adjournment, court will give it.
Your lordship is correct, lordship. I agree with lordship.
We'll fix it in the next week.
It depends, my lord. If on that date also, my lord, I have to take the
What is the
availability.
state's stand?
My lord, the state, we have nothing much to say, my lord, because we have not even filed an appeal against all the bill.
Then it appears, I don't know, that your criminal petition does not have much merit.
That you will see, my lord. Your lordship will see.
But you don't want to let me to see it. You want only to defer it, as you are doing.
No, my lord. The thing is, since all the briefs are also with the senior counsel, so I am actually in a handicapped position right now to take up the matter. That is why, my lord,
Okay, you suggest a date.
if it may kindly be taken up, my lord, 18th of March, lord.
All matters.
All matters all together on that date.
No, we have no objection as such.
Okay. Heard Mr. C. Zoram Chana, learned counsel for the petitioner. Also heard Ms. Linda L. Farmwell, learned public prosecutor, Mizoram, as well as Mizoram for the state respondent, as well as Mr. Jordan Rohming Thanga, appearing for respondent number 2 and Ms. Vanlal Thamwani, you are appearing for?
Respondent to
In some cases. Jordan Raming Thanga as well as Ms. Vallal Thamwani, appearing for respondent number 2. Common order.
Right.
Learned counsel for the petitioner has submitted that he is being led in these cases by Mr. who?
Naresh Kaushik, senior counsel.
Naresh Kaushik, learned senior counsel who is an outstation advocate, and he prays for an adjournment on the ground of personal difficulty of the conducting senior counsel for the petitioners. Learned counsel for the respondents raises no objection to the said prayer. It appears that these matters pertains to cancellation of bail granted to respondent number 2, and these are pending for more than an year and are required to be disposed of at the earliest. Hence, this is for the last time the prayer for adjournment is granted at the behest of petitioner's side. Let these matters be listed on 18th of.
Actually, my lord, if it may be taken up on 19, because 18 might be a day of DB, lord.
19th of March.
19th of March.
19th of March. Okay, 19th.
Obliged, Lord.
All cases.
Item 6.
6 and 7 also, my lord, they are connected matters also. Even as we are the respondent hearing in these 2 cases, my lord, they are Mahindra matters taken up by the same council, my lord. So if it may kindly.
Who is for the petitioner?
My lord, I'm for the petitioner. In items 6 and 7.
What are the prayers?
My lord, for quashing of the second FIR.
There are 2 FIRs filed in the same offence, also. That they are now seeking for quashing of the second FIR.
And what is the status of the?
My lord,
Is
the
it in the-
respondents are yet to file their affidavit.
No, not of this case. Whether investigation is going on or whether
Completed,
Charge-
lordship.
charge sheet has
Charge
been
sheet-
laid.
Already, yes.
Charge sheet has been laid
Late and filed to the court, my lord,
and
in both cases.
trial is proceeding.
Actually, in the second FIR, no, my lord. Not yet. Only in the first FIR, trial now is going on, but in the second FIR, it's still.
On the basis of second FIR, whether separate charge sheet was laid.
Yes, my lord. Separate charge sheet is filed.
That has been stayed.
Actually,
Whether that has been stayed,
not actually stayed, my lord,
then why it is not proceeding?
because we are now in the process of consideration at the step, because it's now been adjournment for some time, my lord.
Item number
My
6
Lord,
and 7.
item 6, 7, 9, 11, 12, 13, 14
Yes, they are
and
all
15 are
challenged to the second FIR, my lord. By different,
councils are same.
no, my
Different.
lord, different.
Item 6, 7,
6, 7 is Mr. Malhotra. 9 is Mr. Jordan. 11, 12, 13 Mr. Malhotra.
and 15, 16, my lords.
15, 6, 15 and 6. 15 is actually petition filed by Mahindra. This is regarding cancellation of bail.
No, no, my lords. 14 is challenge to bail. 15, 16, 17 are, my lords, challenge to the second charge sheet. Second
So
FIR.
they are actually intertwined. Some of them are challenged to bail order, some of them are challenged to
Any-
second FIR.
all cases you
My
are
lord.
there, you are there.
My lord, for
And
the
you are
Mahindra.
seeking adjournment.
Exactly, my lord.
Then in 6, 7,
9.
6, 7, then
9,
9,
11 to
11,
11, 12, 13,
9,
14,
11, 12,
15,
13, 14.
15, 16 and 17 also.
Write the name of the party, council from the cause list. You give the name of the council. Mr. C. Joram Chana, you have anything to say?
Yes, my lord, regarding item number 16, the AD card has not been returned, my lord. Notice was issued on 27/11/2025, my lord.
Okay,
Through registered
we'll
post.
pass separate orders in 16. In others, write the name of the council, then Mr. C. Zoram Chana, Lanet Council for wherever it is respondent, mentioned respondent, has prayed for an adjournment on the ground of personal difficulty of the leading senior counsel for the respondent. The other side have not opposed the prayer. Hence the prayer is allowed. When we can take it up? A separate date,
No, same date, my lord, 19th of March.
19th of, let this matter be listed.
My lord, item 22 also is included there.
We'll come to that.
Item
19th,
22.
19th of March. Item number 16, give item number 16. Yes, 16, Miss Rosie, what is your submission?
This petition is seeking for quashing of the second FIR, my lord.
You are the petitioner.
Yes, I'm the petitioner, my lord.
Who is the respondent number?
But my lord, in this case, the AD card has not been returned, my lord. Item number 16.
Okay. We'll wait for AD cards. Heard Miss Rosie Manlavam Sangi, Learned Counsel for the petitioner. Also heard Miss Linda L. Farmwell, Learned Public Prosecutor appearing for the state. It appears from the office note dated 2/2/2026 that the note AD card in respect of notices sent to respondent number 2 have not yet been received. Await further. List this matter on 19th of March.
In the meantime, in that case also, my lord, I represent respondent number 3, isn't it? Mahindra. But regarding number 2, he is arrayed as an individual, so it has to be personally represented. So that is what we are now waiting, my lord. Regarding the Mahindra, my lord, I represent.
Show the presence of Mr. C. Zoram Chana appearing for respondent number 3 on 19th.
Obliged. Deeply obliged.
Oblige.
In that lawsuit, 22 is included, isn't it? 22 also, item 22 also is included. 21, no, 22, only 22. 22 also.
Who is for the
In
petition?
item 22, my lord, I am appearing for the petitioner. I have taken steps upon the respondent number 2, and as per the office
You
note-
are Victor.
Yes, my lord.
Heard Mr. Victor L. Ralte. Where is the file of 22? L. Ralte, learned counsel for the petitioner. Also Ms. Linda L. Farmwell, learned public prosecutor.
Can I accept notice on behalf of respondent number 3, Mahindra?
Yes. And Mr. C. Zoram Chana, who appears for respondent number 3. It appears from office note dated 2/2/2026 that the AD card in respect of notices sent to respondent number 3/2 has not yet returned. Await. You have sent it when?
On 6th of November,
Stop. The registry is directed to place the postal track consignment report of the notice sent to the respondent number 2 by speed post. By speed post on the next date fixed. Let this matter be listed again on 19th of March.
Obliged.
Item 8.
My lord, pleadings are completed in this matter, and if it can be fixed for admission hearing this Friday, this coming Friday.
It is fixed today for admission.
My lord, we have recently received the affidavit filed by respondents
Okay.
2 to 4. So it may be listed on Friday for admission hearing.
Okay. Any objection? Anything, Ms. Zairem Sanpui?
I am for respondent number 1 and
Heard
5.
Ms. Vanlal Thla Muani, learned counsel for the petitioner. Also heard Ms. Zairem Sanpui, learned central government counsel appearing for respondent number 1 and 5, as well as Ms. What is your name? Where is her name? Michael. Just a minute. Also heard Ms. Lalnun Lui appearing for state respondents. It is submitted by learned counsel for the petitioner that they have received the affidavit in opposition very recent, filed by the respondents very recently, and hence prays for listing this matter for admission hearing on 6th of this month. The prayer is allowed. Let this matter be listed for admission hearing on 6th February accordingly.
Oblige.
Item 10.
Please, Your Lordship, if I may be granted time to file additional affidavit. In the last court date, we were given the liberty, if so advised, to file additional affidavit. So I have discussed the matter with the concerned officials, and then we have decided that additional affidavit should be filed in the matter, so as to make clarification as to the doubts.
Okay. Heard Mr. Victor L. Ralte, learned counsel for the petitioner. Also heard Ms. Mary L. Kante, learned counsel for respondent number 125, who prays for allowing the respondents to file an addition, for some time to file an additional affidavit. The prayer is allowed. When?
2 weeks, Your Lordship.
Let this matter be listed after 2 weeks on a date to be fixed by registry.
Deeply obliged.
Item 18.
May it please your lordship, on behalf of the state respondents number 1 and 2, the affidavit in opposition has already been filed. And as to the respondent number 3, your lordship, I've received the pairwise comments just yesterday. So if I may be granted at least 2 weeks time to file the affidavit, your lordship.
Okay, heard. No, just a minute. This is item number 18. Heard Miss Vanlal Thlamwani, learned counsel for the petitioner. Also heard Miss Lan Nun Lui, learned government advocate, who submits that she has received pairwise comment from respondent number 3
Yes, sir.
recently and needs some time to file an affidavit in opposition. The prayer is allowed. Let this matter be listed after 2 weeks.
Much obliged, your lordship.
Item 19.
My lord, the pleadings are also completed for this matter, and if it may be fixed on Monday for admission hearing.
Monday is okay?
All right, my lord, we'll try. We have some other fixed matters, that is why.
Meanwhile, my lord, if I may be given the liberty to file for reply affidavit, if any,
Then you file the reply affidavit.
if any, my lord.
Heard Miss Vanlal Thlamwani, learned counsel for the petitioner. Also heard Miss Linda L. Farmwell, learned additional AG, appearing for the state respondent, as well as Miss
Daphne Shoitlongi, my lord. I'm appearing on behalf of my senior for respondent number 4 and 5.
What is your name?
Daphne Shoitlongi.
I'm not getting it. Write her name. Or Daphne Lal Roat Luangi, learned counsel for respondent number
4 and 5, my lord.
4 and 5. Learned Counsel for the petitioner submits that some time may be granted to file an affidavit in reply if required, and prays for listing this matter for admission hearing on Monday.
My lord.
That is on 9th of February. The prayer is not opposed to by the learned counsel for the respondent side. Hence, same is allowed. Let this matter be listed accordingly.
Item 20.
My lord, I'm appearing for respondent for, and if I may be granted 1 week for filing affidavit in opposition.
What is your name? Your petitioners.
My name Karthik Jain, sir.
Heard Mr. Karthik Jain, learned counsel for the petitioner. Also heard Ms. Vanlal Thlamwani, learned counsel for respondent number 4, who prays for a week's time for filing affidavit in opposition. Also heard Ms.
Lalnun Louis, Your
Lalnun
Lordship.
Louis,
For respondent number 1
learned
to
government
3.
advocate, appearing for respondent number 1,
We have filed an affidavit, Your Lordship.
who submits that the state respondent has filed their affidavit in opposition. Stop. Considering the submissions, the prayer made by learned counsel for respondent number 5 is allowed. Respondent number 4 is allowed. Let this matter be listed after a week on a date to be fixed by registry.
My lords, 1 week additional for filing affidavit in reply, and there is an interim stay that may be extended till next date of hearing.
Let the interim order shall remain, shall be extended till next date. Let this matter be listed after 2 weeks.
Obliged.
You file affidavit in opposition after a week, and then you file your reply if required within that week.
Obliged, my lords.
Item 21.
Yes, what is this?
My lord, this is a criminal petition for bail conditions modification.
What modification you are wanting?
My lord, if I may take your lordship to page number 3 of my petition.
Michael, BNSS. Yes, what is the submission?
My lord, if I may read this para number 3 at page 3.
Yes.
That the learned special judge of NDNPS Act, Aizawl, was pleased to grant bail to the accused petitioner in bail application number so-and-so with the following bail conditions. A bail bond of 5 lakhs only with 2 sureties who shall also execute the same amount of bond. And number 2, 1 surety shall be permanent resident of Aizawl duly living in his or her own house. 1 surety shall be any regular government servant not below the rank of LDC posted at Aizawl, duly certified to this effect by the controlling officer, head of office.
Pramod
That, my
Yes.
lord. That, my lord, the petitioner is not from Mizoram. He's from other state, from Manipur. So, my lord, it is very difficult since the bail bond is very high and he could not execute the bond. He could not find any sureties who would stand as surety.
When
in
the
this
bail
case.
was granted?
My lord,
What
my
is
lord, it's at annexure number 3, page 14. It was granted on date of order is 15/9/2025, 15th September.
Yes, Ms. Mamdel. Should we call for the record of the bail case or we can dispose it off?
I think, my lord, we can dispose it off.
Yes.
My objection is that, my lord, the bail bond is high, but it's not that they have to deposit the bail amount. It's just to secure his presence, my lord. And since he is from a resident of Manipur, not from Mizoram, his chance of absconding is very high. That is why this bail bond amount is given as...
No, they are not opposed to the quantum of the bail bond. They are opposed to the condition that one permanent resident of Aizawl has to be a surety.
My lord, if I may, we had also prayed for reduction of the bail amount.
They have
How
asked for
much?
two-
How much contraband was involved?
301 grams of suspected heroin.
How much is the cost of the?
Cost, my lord, it's a commercial quantity. One second. I have not seen the cost. my lord.
No, bail amount is okay.
My lord, in the charge sheet, the estimated value is 9,04,000 in the charge sheet. "27 soap cases weighing 301.57.
No, how it matters? What is the bail amount? How bail amounts matters?
Bail amount is too short.
Because the offence is also very grave.
That is true, my lord. However, my lord, it's as you will be well aware that a stringent condition should not be imposed.
No, it should be imposed in cases involving NDPS cases. Offence like any other submission.
Yes, my lord. To substantiate my submission, if I may rely on one citation.
Yes.
My lord, if I may take your lordship to page 11. Para 7.1.
Para?
Para 7.1 at the top of page 11.
Yes.
We are, if I may read,
Please read.
we are dealing with a case of the accused whose guilt is yet to be established. So long as he is not held guilty, the presumption of innocence is applicable. He cannot be deprived of all his...
What were the facts of this case? How much?
My lord, the appellant is prosecuted for offences punishable under Section 8, Section 22, 23 and 29 of the NDNPS Act.
Thereafter?
Yes, my lord.
Is it also a case of reduction of bail amount?
Yes, my lord.
No, it is for modification of a condition not to leave the country.
Yes, my lord. My lord, this is also, we had asked for bail modification, bail conditions, modification of the bail conditions.
Yes, please read 7.
The courts, if I may continue, he cannot be deprived of all his rights guaranteed under Article 21. The courts must show restraint while imposing bail conditions. Therefore, while granting bail, the courts can curtail the freedom of the accused only to the extent required for imposing the bail conditions warranted by law. Bail conditions cannot be so onerous as to frustrate the order of bail itself. For example, the court may impose a condition periodically reporting to the police station / court or not traveling abroad without prior permission. Where circumstances require, the court may impose a condition restraining an accused from entering a particular area to protect the prosecution witnesses or the victims. But the court cannot impose a condition on the accused to keep the police constantly informed about his movement from one place to another. The object of the bail condition cannot be to keep a constant vigil on the movements of the accused enlarged on bail. The investigating agency cannot be permitted to continuously peep into the private life of the accused enlarged on bail by imposing arbitrary conditions, since that will violate the right of privacy of the accused as guaranteed by Article 21. Then, my lord, if I may skip and then if I may continue reading from page number 15. Para number 10.2.
Yes.
My lord, here, imposing any bail condition which enables the police investigation agency to track every movement of the accused released on bail by using any technology or otherwise would undoubtedly violate the right to privacy guaranteed under Article 21. In this case, the condition of dropping a pin on Google Maps has been incorporated without even considering the technical effect of dropping a pin and this relevance of the said condition as a condition of bail. Thus cannot be a condition of bail. The condition deserves to be deleted and ordered accordingly. In some cases, the court may have imposed similar condition, but in those cases, the court was not called upon to decide the issue of the effect and the legality of such condition. That, my lord, here in this case as well, this is not in our case, it is very high, even though it doesn't necessarily ask to be deposited, the bail amount. However, since they could not produce the appellant, the innocent appellant could not produce the 5 lakhs each, means 2 sureties, that comes to 10 lakhs. So he could not produce, and then he doesn't have that much amount of money. And without depositing it, he could not find any surety who would stand on his behalf. So that is why.
But the case which you have cited have different facts.
It's different facts. However, my lord, if we continue reading it, the conditions are not acceptable. That is the principles of law that I would like to portray, my lord.
In NDPS matters, what should be the conditions according to you?
In our prayer, we had asked for 50,000 each for the surety. But however, my lord, if you think that is too
has
less,
to be irrespective of the contraband recovered. Suppose the quantity of contraband recovered is of huge quantity.
yes, my lord, in the market value, it's estimated as 9 lakhs.
Yes, any other submission? Any other submission?
Then, my lord, we had asked for bail bond reduction to 50,000 from 5 lakhs to 50,000 each. And the other condition is that the condition number 2 is that one surety shall be permanent resident of Aizawl, and another surety is a regular government servant not below the rank of LDC posted at Aizawl. My Lord, in our prayer we had again asked, since he is a resident, permanent resident of Manipur, so if any government servant within the territory of India be allowed for the ends of justice.
Okay.
That is our prayer, not just Aizawl.
And
Those two are our prayer for modification of bail conditions.
just out of two sureties, one has to be a permanent resident of Aizawl and one has to be government servant posted at Aizawl. This you want, that posted at Aizawl restriction should not be there.
Yes, my
In
lord.
case
Any
of
government
second,
servant, yes,
and
my
in
lord.
case of first surety,
For surety, I think that is
okay.
okay, I think.
Okay. Yes, Ms. Fambil.
My lord, like I've stated, the conditions is only to secure his presence, my lord, so that he did not abscond. Now, my lord, the court has given on these two conditions so that his presence can be secured. And the first condition, my lord, 5 lakhs, it can be reduced to some amount, but not this 50,000.
Okay.
And
second condition?
the second condition, my lord, any regular government servant not below the rank of LDC posted at Aizawl. My lord, any regular government servant posted at Aizawl will also do, my lord, in this case.
But how they will find a government servant in Aizawl?
That is another. Yes,
It may be
difficulty, my
difficult
lord.
because he is not from
Not from Aizawl.
Aizawl. Heard Miss Lal, what is your
Lal
name?
ngai saki fanai.
Lal?
Lal ngai saki fanai.
Lal Naksaki Fanai,
Yes, my lord.
learned counsel for the petitioner. Also Miss Linda L. Farmwell, learned public prosecutor. This criminal petition has been filed by Shri Lian Chung Nunga in connection with what is the bail application number?
353 of 2025. My lord, before the High Court? Or?
No.
Okay. It's
You-
353 of 2025.
What was the last sentence? We're not in connection. File for modifying the bail conditions imposed by the learned Special Judge NDNPS Act, Aizawl, while granting bail to the petitioner by its order dated 15/9/2025 in bail application number 343 of 2025. Learned counsel for the petitioner has submitted that the petitioner is an accused in connection with, where is the bail application?
At page 14, my lord. Annexure number 3.
connection with what is this BKN stands for? BKNPS?
Bongkon. Bongkon is the name of the police station.
Okay, in connection with Bokon PS case number 174/23 under section 21C/2129/25 of the NDNPS Act 1985, wherein an accusation has been made against the petitioner of possessing 301.57 grams of suspected heroin. She submits that the petitioner had approached the Court of Learned Special Judge NDNPS Act Aizol for grant of bail, and accordingly grant of bail stopped. It is further submitted that by order dated 15/9/2025, passed in bail application number 343/2025, the petitioner was granted bail by the Court of Learned Special Judge NDNPS Act Aizol. However, she submits that while granting bail, following conditions were imposed. Number A dash small a bail bond of rupees 5 lakhs with 2 sureties who shall also execute the same amount of bond. Number B, one surety shall be permanent resident of Aizol, duly living in his/her own house, comma, one surety shall be a regular government servant not below the rank of LDC, posted at Aizol, duly certified to this effect by the controlling officer/head of office. She submits that, next paragraph, she submits that, no, learned counsel for the petitioner submits that the condition imposed by the trial court while granting bail to the petitioner are onerous, and the petitioner is unable to fulfill them. She submits that the total estimated cost of the seized contraband as reflected in the charge sheet is rupees 9 lakh only, and in that context the bail bond of
9,04,000.
9 lakh approximately, and in that context he submits that the amount of bail bond to the extent of rupees 5 lakh is onerous, and the petitioner is unable to find suitable surety who are ready to execute bond to that extent. Hence, she submits that the amount of bail bond may be reduced. She also submits that the petitioner is the permanent resident of the state of Manipur, and he does not know anyone from Aizol city, and therefore it has become difficult on his part to find a surety who is a government servant posted at Aizol. She submits that the petitioner will be able to provide surety, including a government servant, provided the condition that he should be a he should be posted at Aizawl should be relaxed. She submits that the petitioner was granted bail by the trial court way back on 15/9/2025. However, as the conditions were too onerous, he is unable to find suitable sureties even after 4 months of the grant of bail, passing of the bail orders. Therefore, she submits that the bail order may be modified. In support of her submission, she has, learned counsel for the petitioner has cited a ruling of the Apex Court in the case of Frank Vitas versus Narcotic Control Bureau within bracket SLP within bracket criminal number 6339646340 of 2023, wherein the Apex Court has observed that while granting bail, the courts can curtail the freedom of accused only to the extent required for the purpose of imposing bail condition warranted by law. It also observed that the bail conditions cannot be so onerous so as to frustrate the order of the bail itself. She submits that in the instant case, due to the bail conditions imposed by the trial court, the petitioner has not been able to fulfill the same even after 4 months of the grant of the said order. Stop. On the next para. On the other side, Ms. Linda L. Farmwell, learned public prosecutor, has opposed the prayer for modification. She submits that since the offence in this case involves possession of commercial quantity of contraband, hence the condition imposed by the trial court is proportionate to the severity of the offence involved in this case. She, however, submits that considering the value of the seized contraband as reflected in the charge sheet, the amount of bail may perhaps, she does not have any objection, is amount of bail is reduced to some extent. However, she is opposed to relaxing the second condition of requirement of a government servant, as if such condition is relaxed, she submits that it may be difficult to procure the attendance of the petitioner during trial. Stop. I have considered the submissions made by learned counsel for both sides. It is true that considering the nature of offence involved in a case, the court granting bail to an accused may impose certain conditions so as to procure his presence during trial. However, as observed by the Apex Court, the bail conditions cannot be so onerous as to frustrate the order of the bail itself. In the instant case, the quantity of contraband involved in this case is 301.57 grams of suspected heroin, which is a commercial quantity. However, it also appears that in spite of getting bail order in the month of September 2025, that is on 15 September 2025, the petitioner has not been able to arrange suitable surety due to the onerosity of the condition imposed by the trial court. So after considering the submissions made by learned counsel for both sides, and after considering the facts and circumstances of this case, the condition number A attached to the bail order dated where is the bail order?
My lord, at page 14.
Bail order dated 15/9/2025 passed in bail application number 343/2025 is hereby modified from rupees 5 lakhs to rupees 2 lakhs. And the condition number B is also partly modified, that the one of these sureties should be a government servant posted anywhere in India in place of posted at Aizawl. Is it okay?
Yes, deeply obliged.
This criminal petition is, with above direct observations, this criminal petition is accordingly disposed of.
Highly obliged, my lord.
For orders, item 23.
Yes, what for this IA is?
Lordship, I is for condonation of 344 delays.
Delay, yes, yes. What
It's an
is
appeal
this?
against acquittal.
Acquittal also.
And for that purpose, they have filed leave to appeal, special leave to appeal. And against the, in terms of the section 419 of the BNSS, my lord, there's a prescribed period for filing an appeal against acquittal. There's a delay of 344 days in preferring the appeal.
Section 41?
419 of BNSS law.
Section 419, subsection 5.
Yes. Please read.
Lordship. No application under subsection 4 for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months, where the complainant is a public servant, and 60 days in every other case computed from the date of the order of acquittal. Lordship, this appeal is filed by the Union of India, represented by the government servant. So section 415 of the BNSS 2023 was invoked, Lordship. And by filing this special leave application, there was a delay of 344 days. Hence this application, Lordship. And I have
This
explained the reason of delay. Lordship.
No, just a minute. This application is under section
419
5.
5 of the BNSS.
But 5 does not say anything about condoning the less.
5 it says that no application under subsection 4. Subsection 4 is regarding the acquittal.
Yes.
So here it says that subsection 4 for the grant of special leave. Also, we have filed a special leave application before this honorable court, and
That
by
is-
filing
that is
by filing
after
that
our-
special leave petition, then
That
there
is
a
after delay.
Yes, Lordship.
Now 5 speaks about the bar,
The bar,
the
Lordship.
limitation.
Lordship, yes.
Where is the provision that that limitation may be condoned?
Lordship, may I read again, Lordship?
Yes.
No application under subsection 4
Limitation.
for the grant of special leave to appeal from an order of acquittal shall be entertained by the High Court after the expiry of 6 months, Lordship. The limitation period for filing the
Is
special
6
leave
months.
is 6 months.
Yes.
So after the expiry of the 6 months, as per my humble understanding, we have to file the application for the continuation of delay, Lordship.
Under what provision?
Lordship, I'm invoking this section 4195. 419.
But that does not provide anything for condoning the delay.
But here it specifies, Lordship, the a limitation period for filing the special leave petition.
Yes.
Since we are not within the time limitation period, so we have invoking this 4195 of
No,
the
my
BNSS.
query is whether 419 clause 5
Lordship, I understand. Yes.
provides that the delay,
Has
that
to be
the
condoned.
prescribed period of limitation may be condoned also under so and so circumstances. Is there any provision?
Lordship, here it does not clearly specify as
Then,
such, Lordship.
then under what provision you are seeking?
Also, under the BNSS, there may not be another relevant provision. I have done my research in this regard.
Then there is no provision.
That's-
Which power I will exercise? Now you have to help the court.
I understand also. Yes.
Which power I will exercise?
So, Your Lordship, this Honorable Court has a power to invoke this 4195,
419 is the power to stop.
419.
Mr. Tochang,
Lordship, yes.
what I understand that 419 provides for a bar that if something is beyond 6 months, don't allow it to enter. No leave application may be filed after 6 months. So 419 only gives power to the court to block. No, but your prayer is to
Condone the leave.
seek exemption from that block. Where is that power? You show me that power.
Lordship, from the plain reading
In
that,
f-
yes.
Yes, in plain reading I am not understanding. Either I am not understanding or you are unable to make me understand.
As if from the plain reading that it was not clearly specified that,
Let us read again.
Lordship, yes.
Read, please. read.
No appeal under subsection 4 for the grant of special
Subsection 4 provides
Subsection-
for special leave to file an appeal against acquittal.
acquittal, Lordship.
Unless that special leave is granted, appeal may not be registered.
Very true, Lordship.
But that special leave application has to be filed within 6
6
months
months.
of the date of the judgment.
Lordship, yes.
That is provided in clause 5.
Clause 5.
That limitation is provided in clause 5. You are seeking condonation of that delay period. Which provision is to be made applicable? Or this court has inherent power? Because section 5 of the Limitation Act is not
Yes.
applicable.
Not applicable.
So show me the power. $528.
528 is the current
You have any authority in
Oh.
support of your submission that such a delay may be condoned?
Lordship, yes, I have 3 citations, but not regarding the this 4195 of the BNSS.
No, but we are on 4195.
419, Lordship.
5.
Then if your Lordship thinks that, then I may be given a short time, or maybe tomorrow, or like, because I have to read.
Okay, I'll put a query. You answer that. What is your submission?
Let my learned friend be satisfied on the next day, my lord. Subject to that, I'll make my submission.
Okay. Heard Mr. Johnny L. Tochang, learned counsel for the applicant. Also heard Mr. Victor L. Ralte, learned counsel for all the respondents.
Yes, my lord.
State is also no.
No, no, Lordship.
This application under section 419 within bracket 5 of the BNSS, 2023 has been filed by the applicant, that is Union of India, for condonation of delay of 344 days in filing the special leave application in the connected criminal appeal, whereby the judgment and order dated 25/1/2024 passed by the Court of Learned Chief Judicial Magistrate Champai in criminal complaint case number 16/2022 has been impugned. Stop. At the outset, a query was posed by this court as to under what provision this court has power to condone the delay prescribed under section 4195 of the BNSS, 2023. Stop. Learned counsel for the petitioner prays for some time to answer the query posed by this court. The prayer is allowed. When?
Monday, next week, Monday, Lordship.
Let this matter be listed again on 9th of February 2026.
I'm over.
Item 24.
May it please your lordship, on behalf of the state respondents number 3 to 6, it is submitted that the state will not be filing any affidavit, but we will be adopting the written objection of the private respondents, your lordship.
Who is for the private respondent?
I'm for the private respondents, my lord.
Your Lordship, the submission that they will not be filing for the parties should be recorded because in the last court date, not in the last court
You
date,
are
but
appearing
in
for the?
the appellant, the applicant, sorry.
You are government advocate.
Yes, for JICA. In this matter, JICA, Your Lordship.
No,
And I'm
but-
led by my learned friend.
JICA is a private party.
Yes.
But as government advocate, can you take a case where the state is the respondent?
Your Lordship, there is no conflict of interest in the matter. That is why we can take up the matter.
Why you are on one side you are government advocate, the government is a respondent in this case also.
We were all the respondent in the main case. And we think that there is no conflict of interest. JICA is a funding company, and the state is an implementing agency.
Okay, you are on the same side.
Yes.
Yes. Petitioner, what is your submission?
My lord, if there is no other objection, so if this matter may be listed for hearing.
Hearing or admission hearing?
Admission hearing, my lord.
Admission hearing, Your Lordship. If a date can be, if it is fine with my learned friend on March 12th.
February,
Sorry, February.
next week. Your Lordship, I'm on behalf of the plaintiff.
February 12 hearing will be difficult.
Okay.
No, we will be coming to Aizawl only. We are right now taking the online. Last hearing we were in the court only. That's why my submission is
No, except
because
February
the
12, you choose any other date.
So is it, Your Lordship, next week, like after third and fourth week, I have some family functions in my family, so that was their restriction. Next week, you think Tuesday will be fine then? Tuesday, what is the 10th? We have actually a matter before this. Your Lordship, 9th?
9th, we have too many matters.
Okay, so 13th? Which is Friday? Oh, 16, 17, we can take it. Can we take Your Lordship on 23rd? Then Your Lordship, you can fix the hearing after Holi, which is the week commencing from 9th of March, anytime suitable to Your Lordship if you are
Yes,
going to be
suggested
on the
it.
roster then.
Heard. Miss Mary L. Cante, learned counsel for the petitioner. Also heard.
Applicant.
Oh. You are on the same side.
Yes, applicant, Your Lordship.
Learned counsel for this application is for?
For striking out the name of JICA from the matter.
Oh, learned counsel for the applicant. Also heard Miss Lal Nan Lui, learned government advocate appearing for respondent number 326, who submits that the state would not be filing any affidavit in opposition in this case and may be allowed to adopt the objection filed by the state respondents, by the private respondents. Also, Miss Rosie, appearing for private respondent number
1282.
128. And who else is appearing? Miss Zairem Sankui, appearing for respondent number 8 and 3. 83. Respondent number 83. And you are appearing for?
84, 89.
Samuel.
Yes, my lord.
You are appearing for?
Respondent 84, 89 and 90 in the IM.
Mr. Samuel, appearing for respondent number 84,
89 and 90.
89 and 80 and
90, my lord.
90. Stop. This interlocutory application may be taken up for hearing on the next date. Accordingly, let this matter be listed when? On 9th of March. 9th of March.
Your Lordship, with due respect, if I may, yes. The submission that my learned friend made from the Union of India and NHIDCL that they will not be filing me reflected in the order. So as to be
Union
precise.
of India has not made any submission.
My learned friend Zairim Sangpui.
She has not say.
Yes, yes.
She has already made such submission earlier.
They all made the submission earlier, but it was not reflected in the order. So, if it can be reflected here.
But she is not making submission. It is you who. Ms. Zairim Sangpui, Learned Central Government Council, also submits that the Union of India would not be filing any affidavit in opposition in this case and may be allowed to adopt the objections filed by the private respondent in their affidavit in opposition. The prayer is allowed. Let this matter be listed on 9th of March.
Your Lordship, 10th of March, if possible, it is Tuesday. We will be able to travel on Monday. So
Okay.
10th March,
Okay, 10th of March. 10th of
obliged.
Item 25.
Yes, Your Lordship. This is a state appeal against the capital order under Section 10 POCSO Act, Your Lordship. And I believe that the AD card has not been returned yet.
private respondents.
Yes, Your Lordship.
AD cards have not returned. We will await further. Heard Ms. Varnesh Shyami, learned additional public prosecutor, appearing for the applicants. On perusal of the office note dated 2/2/2026, it appears that the service report in respect of notices sent to respondent number 1 and 2 is still awaited. Stop, await further. List this matter after 2 weeks on a date to be fixed by registry.
Deeply obliged.
Item 26.
May it please Your Lordship. Your Lordship, I am appearing for the private respondent, respondent number 1. However, since I have been handed over the incomplete brief from my client and my application for the certified true copy is still pending at the lower court charge, if I may be given 4-week time of filing my written objection.
Heard.
Okay,
Ms.
Vasanthi,
Valentla Moani, learned counsel for the petitioner. Also, heard. What is your name?
K. Vanlal Puya.
K. Vanlal Puya, learned counsel for respondent number 1, who prays for how much time?
4-week times.
4 weeks time for filing affidavit in opposition. How many respondents are there?
My Lord, state is 2 to 4 months
You are appearing
for the statement.
also Mr. Samuel, learned additional AG, appearing for the state respondents. The prayer made by learned counsel for the respondent number 1 is allowed. Let this matter be listed after 4 weeks.
Much obliged.
Hearing list, item 4.
appeal against the conviction, Lordship, under NDPS Act. FIR is a page 2, Lordship, of
Yes.
page 1, Lordship. Mary, Lordship. First, I would like to.
What is your case? In gist, first you tell me what is your case.
Yes, Lordship. Case is that, Lordship, in this case, Lordship, prosecution examined 4 witnesses altogether after charge sheet.
Adjust your mic. Yes.
Yes. Thank you, sir. Lordship, here in this case, Lordship, 4 witnesses examined by the prosecution.
What was the acquisition?
Acquisition, Lordship, that as per FIR, Lordship, I was in possession of a contraband of 524 grams of heroin, Lordship. While 524 grams, if I am not wrong, Lordship.
Okay.
While a Bolero car was towards to Silchar, Lordship, coming from Manipur, and accordingly I was apprehended by the on search, Lordship, and on the spot I was arrested, and thereafter trial was started. Prosecution side examined 4 witnesses. Out of 4, 2 are independent witnesses and 2 are police personnel. One is IO and one is the informant, Lordship. And apart from this, the FSL director was examined, Lordship. Learned trial court, after considering the all aspect, Lordship, the independent witnesses were discarded, Lordship. They were trial court disbelieved their due to their contradiction, but believe on the 2 police personnel. One is IO and one is the informant statement, and convicted the accused person, Lordship, for a rigorous imprisonment of 10 years, simple imprisonment of 10 years, and fine, I think, Lordship, 1 lakh, Lordship, was imposed. Now, Lordship, thing is that, Lordship, prosecution examined 4 witnesses. There were lots of procedural lapses, first of all. They violate section 42 to section 50, Lordship, particularly, and section 61, Lordship. The Bolero was driven by a driver, Lordship. When I was police arrested the accused person, they neither arrested the driver of the vehicle nor seized the vehicle, Lordship. Vehicle also not seized. Driver also not was not arrested. And even in the charge sheet, there were not a single sentence that why they have not arrested them, why they have not interrogated the driver, and why they have not taken the custody of this vehicle.
Vehicle was a taxi or private vehicle?
It was a private vehicle, Lordship.
Okay.
Bolero car, Lordship.
So what is your case? As because driver was allowed to let go, you should also be allowed to let go.
This creates a serious doubts on the prosecution case, is one of the aspect, Lordship. And second, Lordship, as per I think section 50, Lordship, during search, the accused must be informed about his right to be
From
searched.
where the contraband was found? From your body?
Lordship, in the FIR, the informant state that it's my possession. Simple stated, in my possession. While during the cross-examination, he stated no, it was found inside the Bolero car on the belonging of the accused.
Okay.
There was a serious contradiction. The learned trial court completely overlooked this aspect, Lordship.
Okay, now you come to your case.
Yes. First, Lordship, I would like to read the FIR, short FIR, Lordship, page 1. With reference to cited above, I beg to state that on the night of 9/9/2023 at 10 p.m., one Bolero white color beer number AS01E6535, which was coming from the Charachandpur, Manipur towards Silchar, was detained at Sipahi Police Outpost, and checking was conducted inside the vehicle, and recovered 42 showcases containing brown powder suspected to be heroin with the number 4, which was belonged to Jalal Hussain Badwaiya, ages 26, son of such and such, The same were seized in presence of civilian reliable witnesses, Lordship. Now I am coming to the charge sheet, Lordship.
What is your name? Jalal Hussain?
Jalal Hussain, Lordship. Yes, Lordship. Now coming to the Lordship, page 21, seizure, property of search and seizure form, Lordship. 21.4, page 21. Relevant is page 22, Lordship. Here the only seized article is was mentioned 42 sub cases, weight is about 512 grams, Lordship, from the possession of the accused person. No other seizure, Lordship. Now, Lordship, come to page 25, Lordship. Arrest and seizure form, Lordship. Here the particular of the accused, Lordship. Only one person, page 25, is Jalal Hussain Barboya. His particulars was given. Driver was not arrested, and in the seizure memo we found that.
Why driver should have been arrested? What is your submission? Why he should be arrested?
He may be in possession, the joint possession, Lordship, of the contraband. If they interrogated them, it may be, if for the sake of argument, for the time being,
Kept the contraband.
now here, Lordship, under section 313 statement, Lordship, page, I will, yes, page 18, Lordship.
Page
18, Lordship.
18.
Yes.
Yes, what
Yeah.
you want to show?
Yes, Lordship. In under this section, Lordship, the accused was not even asked a specific query, Lordship. Only two questions mainly asked, Lordship. It's a very straightforward formula was adopted by the learned trial court, Lordship, which is in the eye of law, it's unsustainable, Honorable Supreme Court in number of
What
cases.
query was not posed?
Lordship, first of all, one specific query regarding the possession, it was absent, Lordship. A lump sum query was framed, put before the accused, whether it is true or false. And next question, what do you say regarding the allegation? Here he denied that I have no knowledge about the drugs, Lordship. There could be 3-4 more specific query, Lordship, question as per section 313,
No,
Lordship.
what should have been asked which has not been asked? What is your submission? That this question ought to have been asked but was not asked. What is that question?
Whether it was his possession, Lordship, this contraband, Lordship, where it was kept, Lordship, how he bought to this Bolero car, whether it is unrented, whether he was a normal passenger's, Lordship.
No, that question is there in question number 1, that you possess the so many soap cases.
Possess, Lordship, and in his possession is two different things, Lordship.
Okay.
So this also a defective one, Lordship, this statement, Lordship. I will rely later on, Lordship. Now coming to the charge sheet, Lordship. Page 25, Lordship.
What is the ground which you have taken in this appeal of procedural lapse?
One is procedural lapse.
And other?
Other, Lordship, the non-corroboration of the witnesses, prosecution witnesses, they failed to prove this case beyond all reasonable doubt, Lordship. And learned trial courts also failed to do this, Lordship, because learned trial court disbelieved the independent witnesses, Lordship. Whereas the prosecution is mainly, they are based of the case on the statement of the this independent witnesses, Lordship. So after the discarding, after disbelieving the independent witnesses, what remains, Lordship? And also the main contradiction regarding the possessions and recovery, Lordship, it was also contradicted by the IO and the informant also, Lordship.
Yes.
And the non-seizing the vehicle, not arresting the driver of the vehicle, Lordship. These are the main ground, Lordship.
Non-seizure of the vehicle, how it has prejudiced you? How it has caused prejudice to you?
Because, Lordship, is connected to the driver, Lordship. I am not the owner of the vehicle, nor I was the driver of the vehicle, Lordship.
Vehicle is not the subject matter of the case.
No,
it is the contraband.
Yes, but as per 61 of the NDPS Acts, Lordship, 60 or 61, Lordship, the conveyance should be taken into 60. Yes, 60, Lordship. Liability of illicit drug, substance, plants, and conveyance to confiscation, Lordship. In subsection 3, Lordship.
Which section?
Section 60, Lordship. Subsection 3, Lordship. Any animal or conveyance used in carrying any narcotic drug or psychotropic substance or controlled substance or any article liable to be confiscation under section 1 or subsection 2 shall be liable to confiscations unless the owner or of the animal or conveyance proves that it was so used without the knowledge or the conveyance of the owner himself, his agent, if any, and the person in charge of the animal or conveyance that each of them had taken all reasonable precaution against such use, Lordship. So prosecution is saying that vehicle was used.
No, how it helps you? Suppose there is, assuming that there is a lapse.
Lordship.
No,
lapse
my query is, assuming that there is a procedural lapse in not seizing the vehicle, assuming, but how it helps you? How it comes to your aid? Because contraband was recovered from your belongings. So how it helps you? That
no, it's saying by the prosecution. First they have said that it was in my possession. Then they came to the vehicle, that it was kept inside the vehicle. Then they came to the belongings.
My query is whether every lapse of prosecution would help you, your case.
Lord, procedural lapse can vitiate their proceeding, Lordship.
Procedural lapse in not assuming that driver ought to have been made an accused. But how it helps your case to prove your innocence?
I am saying, Lordship, I am innocent, Lordship, because if prosecution interrogated the actual accused, who may be the driver, Lordship, and convince that the investigation goes in other way, Lordship. So it creates a serious doubts on the investigation agency, Lordship, in prosecution case, Lordship.
Okay. Yes.
Yes. Now, Lordship, as per section 42(2), Lordships, power of entry, search, seizure of arrest without warrant or authorization, Lordships. Here, Lordships, police saying that I am taking your Lordship to page 20, the ground of belief. am saying, Lordship, this case was framed and implicated wrongly my accused, Lordship. The ground of belief, Lordships. May I read, Lordships? Page 20.
Yes.
On 19/9/23, 10 p.m., while on duty at Sipahi Police one Bolero, BR number such and such, coming from the Churachandpur, Manipur, arrived at our duty place. Since I suspect the Bolero to carry some contraband article oblique items, I want to conduct search. However, in this instant situation, there is no time to obtain search warrant from the competent authority. Now come to Lordship, page 30. This is his reason to believe, Lordship, an explanation.
Page
30, Lordship. In page 20, he said that there was no time, Lordships. Now, page 30, Lordship. The search was conducted at the night 10 p.m., Lordship. Kindly on the below button, Lordship, issue date, Lordships, 19/9/2023, Lordship. Same date, Lordships. And kindly see the FIR, Lordship, now, page 19. It was filed on 29, Lordships.
What you want to say?
Lordship, this creates the doubt, Lordship, in prosecution case, Lordships.
What creates doubt?
That the FIR was lodged, the incident took place on 19/9/2023 at 9:10 p.m. While the informant filed his reason to believe to search, Lordship, he has stated that I have no time on that instant situation to obtain a search warrant, Lordships. And now the authorization issued on the same date, Lordships. Whereas time was 72 hours. After completing everything, he could send it to the higher authority, Lordships. That means on the spot everything is done. Either they have on the spot they have done everything, or later on it was framed, Lordship. But he has filed the FIR on the next day, on 29, Lordship. So it creates a serious doubts on the police investigation, Lordships, and the prosecution's case, Lordship.
Be more clear that this authorization which you are showing at page 130.
Yes, Lordship.
It was given on 19th.
19th.
The vehicle was intercepted on 19th.
10 p.m. Lordship.
And where is the affair?
Page 19, Lordship. See the date of filing of the FIR, Lordship. It's 29/20/23.
Yes, FIR was filed after search and seizure procedure was over.
Yes.
Because at the spot they could not have filed FIR.
Yes, I also admitting Lordship. But the process of searching Lordship, on the ground of belief, he is saying that no, I am not able to obtain the search warrant as mandated in section 42 of the NDPS Act because I have no time on that instant situation, Lordship. That means he is supposed to send his reason to belief of the search on the next day. Because it was the night time to the higher authority, he should communicate it and then higher authority should authorize a formal authorization may be issued, Lordship. Now, here in this case is adverse, Lordship. Different. Ground of belief also sent on 19, authorization also issued on 19, search was conducted also on 19.
Yes.
Only FIR was on 20, Lordships.
Now what do you want to say now?
That means if the authorization was issued on 19, that means, Lordship, the authorization officer was available at the time of search at the station, Lordship.
Yes. Suppose he is available then.
Yes.
Then what?
They could have obtained it first and then search may be conducted. Now section 50, Lordship, the accused has right to know about his right to be searched before an gazetted officer or before the magistrate.
Only
Lordship.
if it is a personal search.
Yes, Lordship.
Okay. No, in page 19, when the grounds of belief are where the grounds of belief are stated, he might be stating his failure to obtain search warrant from court, not from authorized officer.
The authorization officer issued the search warrant, Lordship. It's proof that he intending that it should be issued to the authorized officer, Lordship, not in court.
Okay, what else is your submission?
Yes, Lordship. Now, Lordship, coming to the and Lordship, this aspect, the right of the accused person, the section 50, never be communicated to him, Lordship. The police, neither in the charge sheet nor in the grounds of belief, nowhere they have stated that they have explained these things, Lordship, to the accused, that he has the right to be searched before an gazetted officer or before the competent court, Lordship. And the law is, in that regard, law is settled, Lordship, in the Arif Khan case, Honorable Supreme Court.
What is the law?
That in Arif Khan, Lordship, the Supreme Court, this compliance of section 50 is mandatory, Lordship.
What compliance?
That the accused has the right to know about his search, and police should inform that he has the right to be searched before an gazetted officer and the magistrate, Lordships.
No, 50 is applicable only if search is made of a person. But the contraband in this case was not recovered from your person. It was recovered from belonging which was there
It is
in the
not I am
vehicle.
saying, Lordship, it is saying by the prosecution that first they are, later they have turned, Lordship. The contradiction was there. But the contraband was recovered from my possession. If it is from my possession, they must comply with the section 50, Lordship.
Suppose it is found from your bag. Will it not be your possession? The bag which you were carrying.
Lordship.
Will it not be your possession?
If it is my bag, Lordship, the prosecution must prove that this bag.
Then it will be your possession.
This
No,
bag is belong to me.
Let me put a query.
Lordship.
Suppose it is found in your bag, from your bag, which was there in the vehicle. Then, whether in that case also section 50 would be applicable. It is not found from your pants pocket or shirt's pocket, but from the bag which you were carrying in the vehicle, which is the case of the prosecution. Then whether section 50 would be applicable. What is your submission?
Lordship, in this, I have to check it, Lordship.
Okay, what else is your submission?
Lordship. Another thing, Lordship, the things I remember now, that there, in the cross-examination, Lordship, they stated that it's to my belonging they have recovered it. But what type of belonging? Is it bag or something else? In the seizure, Lordship, other than this 42 shop cases, there was nothing, Lordship. If it is from belonging, that belonging must be on the seizure list. It should be proved before the court that that belongings belongs to the accused, Lordship. Now, Lordship, I am coming to the prosecution witnesses examined, Lordship. What witnesses says, Lordship?
Yes.
Page 11, Lordship.
Yes.
Yes. Is the case, Your Lordship. I know the accused who is standing before the court today. On 29/2023 at 9 am, a written FIR was received from ASI such and such that on the night of 19/9/2023 at 10 p.m., one Bolero white color beer number AS11E6353, which was coming from Churachandpur, Manipur, proceeding towards Silchar, was detained at Sipai Police Outpost, and checking was conducted. On checking the vehicle, 52 shop cases containing brown powder suspected to be heroin was recovered from the possession of the accused, Jalal Hussain Barwaya. The same was seized and in presence of reliable civilian witnesses, hence the case was registered and I was endorsed as an investigate the same. During the course of investigation, I examined the complainant and recorded his statement. I also examined the accused person and he had admitted his guilt. I also arrested the accused accordingly. Sample of the suspected heroin were drawn in the Honorable Court in such and such first class scholarship. The 42 shop cases of suspected heroin was bunched into 4 exhibits such and such. The sample were drawn, then forwarded to the FSL by dated 16/10/23 under proper escort. This case is also, Lordship, may be noted, Lordship. The contraband was sent to the FSL on 16/10/2023. An incident took place, Lordship, on 19/9/2023. The result of examination by the FSL indicated that the exhibit such and such were found to be heroin. The purity of such is about 79% at the time of examination. The exhibit was found to be heroin. The purity is about 70% time of examination. Hence, the prima facie case under section 21C of the NDPS Act and found to be established against the accused person. Now, Lordship, the cross-examination. That it is a fact that I am the case IO of the instant case. It is a case. It is a fact that I mentioned in this mentioned the seized article in brief fact of the case 42 such and such containing brown powder to be heroin, but not mention the term in grams. It is fact that the information received from the in charge of Sipai outpost, seized article was seized from the possession of the accused. It is a fact that seized article was recovered from the belonging of the accused, but no other belonging of the accused has been seized, Lordships. Serious contradiction, Lordships. It is a fact that vehicle has not been seized. It is a fact that only driver of the accused were board the vehicle. It is also a fact that driver of the vehicle was not arrested by the police. The seizing and arresting officer has not mentioned the reason of not arresting the driver, not seizing the vehicle. It is a fact that no copy of the seizure memo was furnished to the accused person. It is a fact that seized article was seized on 19/9/2023 and sample of the same was sent to the on FSL on 16/10/2023 for expert opinion. Within this period, seized article was kept in PS Malakana before sending the FSL. It is a fact that I visited the PO and re-examined the witnesses who were already examined by the in-charge outpost. It is a fact that arrest information has given to his brother Kabir Hussain. It is a fact that I have not been mentioned the section violated of the accused in the charge sheet. It is a fact that I deport truly before this honorable court. Re-examination the FSL article is 512 grams. It is the IO examination, Lordship. Here we have found a serious contradiction regarding possession and the other things, Lordship. Now, Lordship,
yes.
PW2, Lordship. ASI, who was the informant, Lordship.
No, why are you reading these? What you want to show? That you have to point out.
That they, what in cross-examination, what they have stated and what is in their chief they have stated, Lordships. The contradiction just I am showing, Lordship. In PW2 also same things he has repeated, Lordship, exactly what in the chief, Lordship. But in the cross-examination, Lordship, I am reading, Lordship. It is a fact that I am the complainant of the seizing officer in the case. IO himself is the arresting authority, Lordship. I do not obtain search warrant from competent authority, but I recorded ground of belief. It is a fact that seized article was recovered from the vehicle. It is a fact that seized article was inside the vehicle, kept in the belonging of the accused, but no other belonging of the accused has been seized. His brother belongings, other belongings were handed over to his relatives. It is a fact that vehicle was not driven by the accused, as well as he is not the owner of the vehicle. It is a fact that the owner of the said vehicle was not arrested. It is a fact that there was a civilian independent witness in this case, Lordships. Next, PW 3 and 4 are the independent witness, Lordships. Independent witness, Lordship, I am reading, Lordship, the chief. On 19/9/2023 10 p.m., Sipai police had conducted search and recovered 42 shop cases obtaining brown powder suspected to be heroin from the possession of the accused, which was kept inside the Bolero white color BR number, which was coming from Tirachandpur, Manipur. So I was present when the search and seizure were made, and I also witnessed the police weighing the packaging, the seized article. As such, I put my signature on the seizure memo, Lordship. In the cross-examination, Lordship, that I am the seizure witness of the case. The police seized heroin from the vehicle. I do not know the registration number of the said vehicle, and color of the vehicle was white. It is a fact that I have seen the accused near the vehicle. It is a fact that there was no other person other than accused. It is also a fact that I do not know whether the accused is driver or owner of the vehicle or not. It is a fact that I do not know whether seized article was recovered from the luggage of the accused or not. So here also, Lordship, they have seriously contradicted their own statement, Lordships, in chief and the cross-examination, particularly regarding vehicle seizure and accused identity, Lordships. PW4, in chief, same things he has repeated, that the contraband was recovered from the possession of the accused, which was kept inside the Bolero white color such and such number, which was coming from Chirachandpur, Manipur, proceeding towards Silchar. I was present when search and seizure were made, and I also witnessed the police weighing the packaging seizure article. As such, I put my signature on the seizure map. Now, it is in the cross, Lordship, I am the seizure witness. It is a fact that 42 numbers of cases containing suspected powder had been seized. It is a fact that police seized from the vehicle. I do not know the registration number of the said vehicle and color, which was color was white, Lordships. In the chief, he knew the Bolero number. Cross-examination, he is stating that I don't know the Bolero number. It is a fact that I do not know whether the seized article was recovered from the luggage of the accused or not. It is a fact that I do not know whether the seizing officer obtaining search warrant from the competent authority before conducting the search. I also do not know whether the seizing officer recorded grounds of belief on author before conducting search. It is a fact that I deposed truly before this honorable court. And one is court witness, Lordship, the FSL Director, Lordships. On 15/10/2023, we received a parcel consisting of 4 exhibits packaged in polythene packet enclosed in a proper envelope sealed with wax seal SDPO warranty in connection with warranty case number such and such. The 4 exhibits contained brownish powder that weight range of 2.8 to 9.9 grams. I examined all the said exhibits and found to be heroin with purity of 77%. In the cross-examination, Lordship, 4 exhibits, date is important, Lordship, 25/10/2023, and it is a fact that examined each exhibit scientifically. It is a fact that purity of 3 exhibits, serial number 1 to 3, 79%, and 4th one is 77%. It is a fact that myself examined all exhibits. It is not a fact that I am deposing for before this honorable court. And the statement of the accused, we already discussed, Lordship, section 313 statement. Now, Lordship, coming to the judgment, Lordship, passed by the learned trial court. Start from page 33.
Page?
33 onwards, Lordships. May the whole judgment or only determination, Lordship?
No. What you want to point out?
Point out these, Lordships. The finding of the learned trial court, Lordships. First, the procedural lapses were not elaborately discussed. How they followed the procedural lapse and how it specified the or gave the strength to the prosecution case. Next, Lordship, the overlooked the contradiction of the police personnel witnesses, their chief examination and their cross-examination, Lordship. Learned trial court, Lordship, particularly the independent witnesses were discarded and believed that they were not believable.
Where it is?
It is on the first point, whether the police
Page number?
Page number, Lordship, 38. I am reading the first decision, Lordship, whether the police officer sees the contraband substance herein in possession of the accused person.
No, it is very long. You point out those areas only where you want to emphasize.
Okay, Lordship. Page 40, Lordships. From the medial portion I am reading from the number of the vehicle, Lordship. The said vehicle from the Chirachandpur, Manipur, he stated that further that he was present at the time of search, etc., was conducted and thus acted as a witness. He put his signature on the seizure memo as a witness, his signature. On cross-examination, he stated that he did not know the registration number of the vehicle but knew the color of the vehicle, that was white. He also stated that he did not know whether the contraband substance was recovered from the luggage belonging to the accused. He did not know if the seizing officer obtaining search warrant from competent authority. He did not know whether the seizing officer accorded the grounds of beliefs conducted search. However, PW4 clearly stated that he saw the accused nearby the vehicle and no other else. From the evidence recorded on PW4, this court again noticed certain contradictions. In this examination in chief, PW4 stated that contraband substance were recovered from the possession of the accused, but in the cross-examination he stated that he did not know if the contraband substance were recovered from the luggage belonging to the accused. Another contradiction is found in this statement about the registration number of the vehicle. He did not mention his examination in chief, but registration number of the vehicle, but in the cross-examination he stated that he did not know the registration number of the vehicle. This contradiction in his statement rendered his evidence not fully reliable. No doubt his evidence are weak and could hardly support the evidence of the seizing officer. PW1, namely Mr. David Henry deposed and he knew the accused. Now I am coming to the operative part directly. The result of that evidence, page 42, Lordship, first paragraph. The independent witnesses, namely PW3 and 4, knew little about the case. They both did not know the registration number of the vehicle, both did not mention about the weight of the seizing substance. They did not exactly know where the contraband substance was recovered. This result that the evidence are not trustworthy. However, the seizing officer and the IO, namely PW1 and 2, repeatedly clearly deposed that their evidence are strong enough to prove their case. Hence, in absence of the evidence of independent witness, this court finds it safe to accept the evidence of both the police officer, placing reliance on the ruling of Honorable Kesarilal versus State of Haryana, reported in such and such. Quoted the paragraph, Lordship. Non-examination of independent witnesses not automatically lead to the conclusion that prosecution case is vitiated, Lordship. It is not applicable in this case, Lordship, because this is not a case of non-examination of independent witnesses, Lordship. Here in this case, Lordship, prosecution relied on the independent witnesses. Here independent witnesses were examined, independent witnesses were the main seizing witness, Lordship, seizure witness. So, to my opinion, Lordship, this case is not applicable in this case, Lordship, in this context, Lordship, because it is not a case of non-examination of independent witness, Lordship. And Lordship, in the first part, Lordship, court given weightage to the prosecution witness number 1 and 2, IO and the informant, Lordship, because completely overlooked the contradiction regarding possession, Lordship, and seizing, Lordship. Complete overlook, Lordship.
What has been overlooked?
The contradiction in their statement, Lordships.
Who's?
What the IO and the informant, Lordships, complainant, the police personnel.
Yes, what contradiction?
main contradiction that Lordship, in the chief, they from the beginning, from the FIR, Lordship, they had this contraband was recovered from the possession of the accused person. But in the cross-examination, they said no, the contraband was found in the vehicle inside the belonging of the accused person. This too is major contradiction, Lordships.
Okay.
So, by this contradiction, Lordship, they failed to prove that the possession of the actual possession of the contraband, Lordships. And they also in the cross-examination admitted that no, we also did not seized any belongings, Lordships. And we found in the seizure memo, Lordship, other than this contraband, no other seizure was done, Lordships.
Okay.
And in the charge sheet also, Lordship, they stated that the contraband was seized at the police station, not at the place of occurrence, because there were not available the weighing machine, Lordship. In absence of that, they later on they keep sent to the police station, carried to the police station first, then it was weighed and then seized, Lordship. So, Lordship, for this reason, Lordship, the prosecution failed to establish their case all beyond all reasonable doubt. I am relying on some judgment, Lordship. First of all, as regards the statement reported under section 313 of the CRPC, Lordship, this statement, Lordship.
Yes.
Sir, Shujit Biswas case, Lordships, versus State of Assam.
Para?
Para 12, 13, Lordships. And 6 and 7, Lordships. First, I would like to read this paragraph 6.
On what point?
That the specific query was not asked by the learned tribunal. We have considered the rival submission made by the learned counsel on perusal record. Suspicion, however grave it may be noted, it may be cannot take the place of proof, and there is a large difference between something that may be proved or something that will be proved. In a criminal trial, suspicion, no matter how strong, cannot be and must not be permitted to take place of proof. This is for the reason that mental distance between may be or must be is quite large and debates both conjectures from the sheer conclusions. In a criminal case...
No, to give emphasis to which submission you are relying on
this judgment covered two things, Lordship. One is, as per section 113 regarding Lordship, paragraph 12 and 13 is operative, Lordship.
(313).
It is settled legal proposition that in a criminal trial, the proposed of examination of the accused person under section 313 CRPC, it is made to requirement of principle of natural justice audio alteram veteram. This means that the accused may be asked to furnish some explanation as regards the incriminating circumstances associated with him. The court must take note such explanation. In this case, circumstantial evidence and same is essential to decide whether or not the chain of circumstances is complete. No matter how weak the evidence of the prosecution may be, it is the duty of the court to examine the accused and to seek his explanation as regards the incriminating material that has surfaced against him. The circumstances which are not put to the accused in explanation under section 313 cannot be used against him and must be exhausted from the consideration. The said statement cannot be treated as evidence within the meaning of the section 3 of the Evidence Act, as the accused cannot be cross-examined with reference to the such statement. In Head Singh Bhagat Singh versus State of Madhya Pradesh, this court held that any circumstances in respect of which the accused has not been examined under section 342 of the Code of Criminal Procedure in corresponding 313, it cannot be used against him. The said judgment has subsequently been followed the canon of judgment of this Honorable Court, uniformly taking the view that unless a circumstances against the accused is put to him in his examination, the same cannot be used against him. In another judgment was referred, Lordship. Now, Lordship, paragraph 16, Lordships.
Yes.
Middle portion, Lordship. It is expected that it would have certainly mentioned in the FIR all such relevant facts. The omission on importance of the facts affecting the probability of the case is the relevant factor under section 313 Evidence Act to judge the veracity of the case and the prosecution in Ramkumar such and such. And last part, Lordship, last page, first paragraph, last 2 lines, 3 lines. Hence, even by the stretch of the imagination, it cannot be held that the aforementioned circumstances clearly point towards the guilt of the appellant, and light of such a fact situation, the burden lies not only the accused to prove his innocence, but also upon the prosecution to prove his case beyond all reasonable doubt. In a case of circumstantial evidence, the aforementioned burden proof of the prosecution is much greater. In view of the above, appeal succeed to allow the judgment and order passed by the court below impugned before us is set aside. And next judgment, Lordship, Rajkumar, Lordship.
On what point?
On 313, Lordship.
What point? 313, what point?
That importance of this query, Lordship, the specific query.
That you have already cited one judgment.
Yes.
Then, is it say something differently?
Not differently, but there was a guideline given by the court, Lordships, in paragraph 16.
Paragraph 16.
May I read, Lordship?
Yes.
Yes. It is the duty of the trial court to put each material circumstance appearing in the evidence against the accused specifically, distinctly and separately. The material circumstance means the circumstances or the material on the basis of which the prosecution is seeking his conviction. The object of examination of the accused under section 313 is not enable to the accused to explain any circumstance appearing against him in the evidence. The court must ordinarily eschew the material circumstances not put to the accused on consideration while dealing with the case of the particular accused. The failure to put material circumstances to the accused amount to serious irregularity. It will vitiate the trial if it is shown to have been prejudicial to the accused. If any irregularity in putting the material circumstances to the accused does not result in failure to justice, it becomes a curable defect. However, while deciding whether the defect can be cured, on one of the circumstances will be the passage of time from date of incident. In case of such irregularities is curable, even the appellate court can question the accused on material circumstance which is not put on him. In a given case, the case can be remanded to the trial court from the stage of recording the supplementary statement and concerned accused under section 313. While deciding the question whether the prejudice has been caused, the accused because of the omission of delay in raising the contention in only one of the several factors of the consideration. So these are the guidelines was framed by the Honorable Supreme Court Lordship in this case. And stated the importance of the same lordships. So such kind of irregularities also can vitiate the proceedings, lordships. Now, lordship, in another statement, lordship, regarding the condition of search, lordship, section 50, the Arif Khan lordships, at the rate Arif Khan appellant, state of Uttarakhand lordships. This judgment was passed, I think, lordship, in reference to the Vijay Vishnu, but lordship, I would like to read the operative part, lordship, page, paragraph 23, lordships. Para 23. Para number 23, lordship. Their lordship have held in Vijay Vishnu Jayaja Supra that the requirement of section 50 of the NDPX Acts are mandatory, and therefore the provision of section 50 must be strictly complied with. It is held that it is imperative on the part of the police officer to apprise the person intended to be searched on the of his right under section 50 to be searched only before a gazetted officer or a magistrate. It is held that it is equally mandatory on the part of the authorized officer to make the suspect.
In this case, whether you were searched or not?
No, lordship.
No. Then where the question of section 50 comes?
Because of three reasons I am referring this judgment, lordship. One is, this question was not asked to me at the time of recording the statement under section 313 of the CRPC.
What question?
That whether I have been searched or not, lordships.
No, there is no evidence, no witnesses saying that you were searched.
Yes, this aspect is totally silent, neither prosecution nor defense.
Then how in 313 it will be asked if there is no evidence?
Because lordship,
only incriminating evidence has to be put before you.
Yes.
If regarding search there was no evidence, you could have explained it in the general question which the court asked as the last question. Do you have anything to say?
But my earlier judgment says the court, it is the duty of the court to put every question, incriminating question separately.
Every incriminating question means that, what I understand, that there is some evidence which is incriminating you in the offense alleged. So somebody must have, there must be some evidence which is to be brought to your notice. If there is no evidence regarding personal search, how this question could have been asked?
No, not only regarding personal search. Personal search is one question, lordship. The other question also.
But section 50 is applicable to personal search only. Okay. Which para 23?
Para 23, lordship.
Okay.
Now, lordship, another judgment, lordship. Mohanlal, lordship, regarding the possession and proof of the same beyond all reasonable doubt, lordships.
Para?
Para 1314, Lordship.
What it says.
Lordship. The duty of the prosecution under NDPS Act, considering the reverse burden of proof, was noticed in Nuraga Shukra observing. An initial burden exists upon the prosecution, and only when it is stands satisfied would be the legal burden shift. Even then, the standard of proof requires the accused to be proved his innocence is not as high as that of the prosecution, whereas the standard of proof requires to be proved the guilt of the accused on the prosecution is beyond all reasonable doubt, but it is preponderance probability on the accused if the prosecution failed to prove the foundational fact as to attract the rigorous section of 35 of the Act. The actus reus, which is possession and contraband by the accused, cannot be said to have been established. With a view to bring within its purview the requirement of section 54 of the Act's element of possessions, the contraband was essential as to the shift the burden on the accused. The provisions being expectation to be the general rule, the generality thereof would continue to be operative. Namely, the element possession will have to be proved beyond reasonable doubt. Para 14. In a criminal prosecution, there is an obligation cast on the investigation not only a fair, judicious and just during investigation, but also that the investigation on the very face of it must appear to be so. Excusing any conduct of impression which may
Continue after lunch. Yes. How much time will you take to wind
Not
up?
much, about 10 minutes.
5 minutes.
Lordship.
Yes.
The judgment which Lordship in Mohanlal Lordship, operative paragraph is paragraph 11, 14.
So beyond reasonable doubt, it
Beyond
has.
reasonable doubt and the fair investigation.
What is regarding fair investigation?
Fair investigation, Lordship, in paragraph 11, Lordship. A fair trial of an accused is a constitutional guarantee under Article 21 of the Constitution would be followed, permissible an investigation in a NDPS case where not to be fair and raises serious question about the fairness apparent on the face of the investigation, Lordship. Same things, Lordship, emphasized in paragraph 15, also Lordship 14, 15, and conclusion is page, last page, Lordship, paragraph 25. In view of the conflicting opinion expressed by the different two judge bench of this court, the importance of the fair investigation for the point of view of the accused guaranteed in constitutional rights
I'll
under
go through it. Para 15.
14, 15. Last 25, Lordship.
Yes.
Yes, Lordship. Finally, Lordship, it was held that it is therefore held that fair investigation, which is but the very foundation of a fair trial, necessary postulates that informant and the investigator must not be the same person. Justice must not only be done, but must appear to be done. Any possibility of bias or predetermined conclusion has to be excluded. This requirement is all the more imperative in law carrying the reverse burden of proof, Lordship. Here in this case, another things, Lordship, this last sentence, the IO is the arresting authority, Lordship. Although he was not the complainant, but he was the arresting officer as well as the IO, Lordship. So,
IO may be the arresting officer.
yes, Lordship, but Honorable Supreme Court discouraged these things, Lordship.
No. It discouraged that complainant and investigating officer. Suppose in a case accused is not apprehended and an FIR has been filed. The investigation starts. It is for the IO to arrest the accused.
Yes, generally.
So IO and arresting officer may be
Maybe
same person under certain circumstances.
Under certain circumstances. But in cases like this, Lordship, Honorable Supreme Court in this case, Lordship, generally discourage such things.
No.
Here only two police personnel was involved. That means one is IO and one other is the complainant was on the raid.
Okay.
So I am concluding my submission, Lordship. In this case, Lordship, the prosecution side, one is procedural lapse was there. Other than procedural lapse also, Lordship, the prosecution miserably failed to establish this case against the accused person beyond all reasonable doubt. Lordship, appellant is a poor man having no knowledge about the drugs. The drugs was neither recovered from his possession nor from his belongings. He was nowhere connected with this alleged offense, Lordships. And also it is on record, Lordship, from the evidence on record, it is also established that his involvement is not there, Lordship, was not there. So he may be acquitted from all the charges, Lordship, under this is my humble submission, under all the circumstances, by taking consideration, Lordship.
Your Lordship, the main contention, if I'm not mistaken, that my learned friend have taken is first is 313. Second is section 50. Third is judgment that was authority that is relied upon in the judgment is not the factual similarity with the instant case. And fourth is proof of possession.
Correct.
Am I missing any?
Position and contradiction of the witnesses.
Okay,
which
contradiction
was
of
overlooked
witnesses.
by police personnel.
I would like to rebut on all the points that my learned friend have taken and then go through the. I will be brief in my submission. With regards to the 313, as Your Lordship already has pointed out, in question number 1 of the 313, whatever the incriminating circumstances that is in evidence that was adduced before the learned trial court was asked was laid before the appellant, and then the answer is in complete denial. It is not a situation wherein there is ignorance of the incriminating evidence.
In 313, whether it was asked to him that from where the contraband was seized.
Yes, but then the question was phrased like this. In 313.
The manner in which the question was asked, how the accused will know from where the contraband was seized.
That you had possessed so and so, brown suspected to be heroin, weighing so and so, brown bolero white color so and so from Chorichampo, where you had been detained. Is it true? No. The question is you had possessed and transported.
How he will know from where the contraband was seized? From this question, if this question is asked to you, how will you know that whether the contraband was seized from the dicky of the vehicle, from the back seat of the vehicle, from a bag, from his pocket, from where it was seized? There is no indication.
There is no indication as such, but then the question number 1 can infer possessed and transported. It means
that is what his submission is.
Yes.
That question has to be specific, so as to give so as it gives a sufficient notice to the accused that these are the allegations.
So yes, my humble rebut to that is that this will suffice. It says possessed and transported.
Who gave that evidence?
The evidence is that of the IO.
How the accused will know that every IO has given this evidence? The question does not indicate that such and such witness has stated so against you, so that he could have contradicted in a proper manner. But here, a very generalized manner question has been posed.
Question was asked. Now, 313 cannot be used for basing the conviction. In this case, it was not used or discussed for basing the conviction.
Maybe, but the court was under an obligation to put the 313 question.
Correct. But then, to my limited knowledge, there is nothing that is written, or there is no authority that says that it should be specifically written that PW number 1 evidence against you is this and that. But then it says that the evidence is that.
Okay.
So that is my answer to that. With regards to section 50, in my humble opinion, section 50 is not attracted at all in this case because there is no bodily search upon the appellant. And before the learned trial court, there is nothing, there is no contest into this regard.
Yes.
And third is that judgment in the authority that was relied upon in deciding that the police evidence is good enough. It's from page number from page number 42 of the impugned judgment and order. The learned trial court has relied upon the Honorable Apex Court authority that is cited in 2013 SCC 595. Now, my learned friend have said that non-examination of independent witness was not automatically lead to conclusion. Now, I am saying that this is not the ratio decidenzi. The ratio decidenzi that is taken by the learned trial court is that if testimony of police witness appears to be reliable, then the court can act upon the same. It does not discuss about the factual situation. Now, the factual situation might be a little bit different as to the factual situation in the instant case. But then the ratio decidendi is this, that testimony of witness appears to be reliable, then court can act upon that. That is the ratio that is taken.
No, the ratio is, in this case, that even if independent witnesses are not examined, only police witnesses are examined, and if they are reliable, court can base its conviction on same.
To my humble understanding, this is the ratio decidendi.
But his submission is that in the instant case,
they were examined.
They were examined and they contradicted the testimony of
Their own testimony.
their own testimony as well as testimony of the police witnesses, in as much as they deposed that they were not aware from which belonging the contraband was recovered.
Yes.
Neither police witness stated in their testimony as to from where the contraband was recovered.
And Your Lordship, with that regard, what I would like to submit is that, first is that I believe that the ratio decidendi that is taken is the phrase that I have read out. Plus, now this impugned judgment and order is under review as of now, as we speak. So we should not trouble ourselves in this.
Which one? Kashmiri law?
Yes.
Okay.
We should not, no, Your Lordship, the impugned judgment and order, the impugned judgment and order of the learned trial court now is being considered at this stage as we speak, in the appellate stage. So we should not concern ourselves on the issues or discussion or whatever was regarded by the learned trial court, since the whole judgment and order is now under reviewed as we speak.
What the appellate court is supposed to do?
To review,
So
to see
if we
through
do
it.
not find fault in the impugned judgment, what else this appellate court is supposed to do?
Your Lordship, my humble submission is that there is nothing wrong in this, that the ratio decidendi that police officers submission before the court on oath, if found reliable, can be acted upon by the court. So that is my submission to this regard.
Okay.
And Your Lordship, to my number 4 is proof of possession. Now, in my humble opinion, the law is very clear. In ND and PS, there is a reverse burden of proof. But before the reverse burden of proof could be retracted towards the accused, then the prosecution has to prove the case beyond reasonable doubt, and it has to stand on its own legs. Now, we have proof beyond reasonable doubt. If I may take Your Lordship kind attention to the position of the case IO,
Page number?
page number 11. The portion that I would like to read out is in the cross-examination, page number 12, paragraph number 6.
Yes.
Paragraph number 4.
it is the fact that seized article was recovered from the belonging of accused and no other belonging of accused has been seized. And number 6, it is the fact that only driver and accused were boarded in the vehicle.
Now, why court will believe when somebody is deposing that it was recovered from belonging? Now, what was that belonging? It was, whether it was a bag, whether it was a carry pack, whether it was a pouch, what belonging from where there is, it is not clear. And the IO also says that the said belonging was not seized. First of all, he does not make it clear what was the belonging. Belonging is a very wide term. Was it a bag? Was it a... Nothing is clear from where, in what form the soap cases were there. And then he says that the driver and accused both were boarded in the vehicle. Why he did not make driver and accused? That is also one of his submission.
Yes. And Your Lordship, in paragraph number 9, it is the fact that seized articles was seized on 19/9/2023 and sample was sent to the FSL on 16/10/2023 for expert opinion. Within this period, the essay was kept in PS Malkana before sending it to the FSL. So, my learned friend also briefly have stated the delay in sending, but then it was in evidence that it was there in the Malkana, which is not rebutted during the trial, during the examination of the accused. And then in page number 11, in paragraph number 3,
yes,
the IO also deposed that the accused person, I examined the accused person and he had admitted his guilt, and I also arrested the accused accordingly. And jumping to page number 13, Your Lordship, this is the seizing officer. The seizing officer have deposed in the examination in chief from in second paragraph from the 5th line. Heroine number 4 from the possession of the accused Jalal Hussain Barbaya. His name was specifically written. From the possession of the accused Jalal Hussain Barbaya. And in the cross-examination,
he does not clarify.
He does not clarify
whether it was seized from his pocket,
yes.
bag.
Yes.
How the court will know whether it was from his possession or from driver's possession?
It says that he's from his possession.
No, it is for the court
from
to
his
decide.
possession, yeah, Lordship.
He
It's
has
clear.
to lay down the facts before the court that it was found in so and so manner. Then
Yeah,
court
Lordship.
will decide whose possession it
Yes. It says that from the possession of the accused, namely so and so. It says that. But in the cross-examination, that is intact, even though they were afforded
will. No,
to
suppose
have the
somebody says it is found in possession of the accused. What you understand? What picture comes to your mind? From where it is?
It might be from my hand or
So,
from
so
my
it is might be.
nearby my
So now
vicinity.
it is not clear.
Yes. But in my humble understanding, it's clear. Coming to this will make it more clear. Page number 14, paragraph number 5. It is the fact that the seized article was inside the vehicle, kept in the belongings of accused.
What belongings?
But no other belonging of accused has been seized. His other belongings were handed over to his relatives. So it was there along with some other of his belongings, even though it is not specifically.
What is the meaning of belonging? Wow.
Belonging is some things which we possess.
Like?
Like it might be physical, it might be, I do not know how to emphasize it properly, but then.
So it is not clear to the
But then it is clear that along with his belongings, that,
What belonging?
that when we travel, we carry some items.
What
it might be
items?
inside the bag, but then it does
Suppose
not say that it
the
is
prosecution
inside the bag.
side is under obligation to prove the charges beyond
Yes,
all
Your
reasonable
Lordship,
doubt.
but then they have proved it beyond reasonable doubt by saying that his other belongings are given to his relatives. It does not say that the bags of the bags containing so and so are given to the relatives. It just says that generally belongings. So along his belongings, it might be contained in a bag or so. It might be contained in a suitcase or so. It does not specifically say that, but then there are some of the belongings that is owned by the which he admitted before the police, which they do not rebut before the court, and then his other belongings were given to his relative, which the relative has also accepted to be the belongings of the accused.
Okay.
It might not say suitcase, black suitcase, brown bag or whatever, but then it contains inside it was found inside the belongings.
Inside what?
Inside the belongings.
What belonging?
And the other belongings, for example, if it is apparel, etc., and then it was happily taken by their family, knowing that it is his belongings.
So your witness does not clearly depose from where it...
No, Your Lordship, in my humble opinion, it's very clear.
Make me understand, if you have understood.
If I say that, for example, I rest
No,
my...
let me put a query. Not for example. From where the contraband was seized, what is your answer?
Inside the vehicle, among the belongings of...
What belongings? What is your answer?
Among the belongings of the accused. Only 2 persons boarded that vehicle.
One of his submission is that even that belonging from where the contraband was recovered was not seized by the investigating officer. Had it been seized, the court would have been in a better position to ascertain whether that could have contained so much of soap cases or not. So that is one of his submission.
From my understanding, Your Lordship, with your permission, there are certain things that was kept inside the vehicle. And among that certain
No,
things...
what certain things? You have not made a seizure list. The IO has not made an inventory.
Because it was given to the relative of the accused, which
No.
they have taken it happily as their...
That
as
I want
the
to understand.
belongings.
What was given to the accused relatives?
The other belongings.
What were the other
items.
belongings?
It was not seized, so how will we know, Your Lordship?
Yes. Was it not the duty of the investigating officer to clarify to the court that from this belonging the contraband was recovered?
They have clarified. They have specifically stated from the belonging of Jalal Hussain Barbaya that they have seized the articles. So they have made it point clear. And then they're given the chance to rebuttal or to make a defense or cross-examination. This is intact in the cross-examination also. And they have failed to prove any claim against it.
Okay.
And now the burden of proof, the reverse burden as per section 54 of the NDNPS Act, once foundational facts is proved beyond reasonable doubt. Now the reverse burden, since it's a special act, the reverse burden to prove his innocence lies with the accused. Now the accused before the learned trial court did not adduce any evidence, first of all. Second is that at the time of, he was duly represented before the learned trial court. And then at the time of taking the evidence, at the time of cross-examination also, nothing as such so as to maintain his innocence was made out. And the foundational facts which was laid by the prosecution, that is that he admitted his guilt before the police and that the seized articles were seized from the vehicle in which he boarded, and it was among his belongings, and his belongings were handed over to the relative. No adverse remark is made in the cross-examination, and it is totally intact. And with regards to the last point, with regards to the contradiction with the evidence of the contradiction of the evidence of the witnesses. Now, yes, with regards to the evidence of the Caesar witness, that is independent witness, there might be some contradiction which the learned trial court also pointed out. But then, to my understanding, whatever the deposition made by PW number 1 and PW number 2 is in corroboration with the with each other. There is no contradiction as such. If my learned friend could point it out the contradiction, major contradiction that would touch the root of the case, then I would be happy to hear it. But then I do not find any, to my limited knowledge and reading, I do not find any major contradiction so as to touch the root of the case, Your Lordship. It cannot be that word by word, sentence by sentence, or phrase by phrase of one person's evidence to another person's evidence could be the same, because they are different persons. So sentencing phrasing will be will be obviously different. The core issue that is that on the night, that is while they were on duty at the checkpost, while they were conducting the search, they have found from the belongings of Jalal Hussain Barbaya that there are 42 soap cases containing 512 grams of heroin, which they have seized and produced before the learned trial court for trial. And Your Lordship, to conclude my submission, I will not produce any citation in this regard because the law is very clear. The foundational facts of the case is proved beyond reasonable doubt by the prosecution in the instant case. And then the reverse burden now is on the accused to show that he is not, as to how the seized article has come into his possession, as to why he was in the vicinity of the place of occurrence. That reverse burden of proof is now, the onus of proof is on the appellant. With that, I rest my case, Your Lordship.
Heard. Mr. What is your name?
T.A. Chaudhary, Lordship.
T.A. Chaudhary. Mr. T.A. Chaudhary, learned counsel for the appellant. Also heard Miss Mary L. Kyangte, learned additional public prosecutor. This appeal, next para, this appeal under section 415 within bracket 2 of the BNSS 2023 has been filed by the appellant, namely Shri Jalal Hussain Barbhaiya, impugning the judgment dated 10/6/2025 and the order dated 25/6/2025, by which the Court of Learned, Fast Track Court, Court of Learned Judge, Fast Track Court, Mizoram, Fast Track Court Kolasib, had convicted the appellant under section 21 within bracket C of the ND-NPS Act 1985 and he was sentenced and the appellant was sentenced to undergo imprisonment for 10 years and to pay a fine of rupees 1 lakh, in default of payment of fine, to undergo further rigorous imprisonment for a period of 6 months. Stop. Next matter. The facts relevant for consideration of the instant appeal, in brief, are that on 29/2023, one Mr. Laleng Mawia, ASI of Sci-Fi Police Outpost, had lodged an FIR before the officer in charge of Wairangte Police Station, inter alia, alleging that on the night of 19/9/2023 at about 10 p.m. one Bolero vehicle within bracket white color, bearing registration number AS11 E6535, which was coming from the Churachandpur, Manipur towards Silchar, was detained at Sci-Fi Police Outpost. Stop. It is further alleged in the FIR that during search of the vehicle, 42 soap cases containing brown colored powder suspected to be heroin were recovered from the possession of the appellant. On receipt of the aforesaid FIR, Wairangte PS case number 39/2023 was registered under section 21C of ND-NPS Act 1985 and investigation was initiated. Stop. Next para. After completion of the investigation, charge sheet was laid against the present appellant. Was arrested at the spot of recovery of the contraband and he has been detained behind the bars since then. Stop. The appellant faced the trial remaining in custody. Stop. The trial court, that is the Court of Learned Judge FTC A Additional Session Judge Kolasip, after going through materials on record and after hearing learned counsel for both sides, on 13th March 2024, framed charges against the appellant under section 21C of the ND-NPS Act 1985. Stop. When the said charge was read over and explained to the appellant, he pleaded not guilty to the same and claimed to be tried. During the trial, the prosecution side examined 4 prosecution witnesses. Including the first informant as well as the investigating officer. The appellant was examined under section 313 of the Code of Criminal Procedure 1973, during which he denied the truthfulness of the testimony of the prosecution witness and pleaded his innocence. However, the appellant declined to adduce any evidence in his defense. Ultimately, by the judgment dated 10/6/2025, the trial court had convicted and sentenced the appellant in the manner as already described in the foregoing paragraphs herein before. The aforesaid judgment has been impugned in this appeal. Before considering considering the respective submissions of learned counsel for both sides, let us go through the evidence of the prosecution witnesses which is available on record. This I will dictate later on. Next para. Mr. What is your name?
T.A. Chaudhary.
T.A. Chaudhary, learned counsel for the appellant, has submitted that the trial court had erred in arriving at the conclusion of guilt of the present appellant, and also by sentencing him to undergo rigorous imprisonment of 10 years. And he submits that the investigation in this case was not conducted in a fair manner, in as much as the investigating officer has not mentioned any reason in the charge sheet as to why the driver who was driving the vehicle from where the contraband was recovered was not made an accused. He further submits that the investigating officer was also wrong in not seizing the vehicle from where the contraband was recovered, as well as mentioning clearly as to which was the belonging of the appellant from where the contraband was recovered. He submits that in the seizure list has been exhibited. Exhibited or not?
Seizure list
Yes or no?
exhibited, Lordship.
What is the exhibit number?
Number I don't remember.
In the seizure list prepared in this case, the seizing officer has only seized the contraband, and it has been shown to have been seized from the possession of the appellant. However, no other belonging of the appellant or any other item including the vehicle, have been seized in this case. He further submits that the trial court did not consider the independent witnesses worthy of any credence, and in the impugned judgment it has been specifically stated by the trial court that due to the contradiction in their statement, they are not worthy of any reliance. However, in spite of that, by merely relying on the official witnesses, namely the first informant as well as the investigating officer, the trial court rendered in the impugned judgment of conviction. He further submits that the trial court was also wrong in placing reliance on the, where is that? Okay. Placing reliance on
Page 42.
the judgment of the apex court in the case of Kashmiri Lal versus State of Haryana, reported in 2013 SCC 595, inasmuch as in the said judgment no independent witnesses were examined. However, the witnesses of the given by the police was found to be reliable in that case, whereas in the instant case, it is, though independent witnesses were examined, they were found to be unreliable by the trial court itself. Stop. Learned counsel for the Learned counsel for the appellant has further submitted that the trial court also erred in not considering the fact that the investigating officer as well as the seizing officer, please read this line again. Erred that the that the seizing officer did not comply with the mandatory provisions of procedural requirement as prescribed in section 50 of the NDNPS Act 1985. He submits that though it has been stated by the who deposed that it was from the possession of the
both IO and
it was
informant.
He submits that though it was deposed by both the investigating officer as well as the first informant, that the contraband was seized from the possession of the appellant. However, the appellant was not informed about his right guaranteed under Section 50 of the NDNPS Act 1985. Hence, he submits that the conviction of the appellant under Section 21C of the NDNPS Act is not justified on that count only. In support of his submission, he has learned counsel for the appellant has cited a ruling of the Apex Court in the case of Arif Khan alias Aga Khan versus State of Uttarakhand, reported in 2019 3 SCC within bracket criminal CRI bracket close 176. Learned counsel for the petitioner, learned counsel for the appellant has also submitted that the prosecution side has not been able to prove the foundational facts required for shifting the burden on the accused under Section 54 of the NDNPS Act 1985. He submits that there is no evidence, he submits that the evidence of the prosecution side is not clear as to from where the contraband was seized. It only speaks about the fact that it was seized from the belongings of the appellant without specifying as to what were those belongings. He submits that under such circumstances, the prosecution side has failed to prove the initial burden of establishing the foundational facts in this case. Stop. He also submits that though the investigating officer, while deposing as PW1, has exhibited the written ground of belief before conducting search and seizure as Exhibit P Roman 2, wherein it has been stated by him that he could not get time to obtain search warrant from the competent authority before conducting the search. However, it appears that, he submits that the what is this? At page 30?
Yes, Lordship.
Exhibit P2.
P2.
And at page 20, it is also Exhibit P2.
Yes, Lordship. In the bottom it has been written 2A, Lordship. P2.
2A, where?
In the page 20, Lordship. Received by such and such. It's signature, sorry. It's a signature.
What was the last line? He submits that the authorization for search under section 41 within bracket 2 of ND and PS Act 1985 was issued by the officer in charge of Wairengte police station on 19/9/2023, whereas the FIR was lodged on 29/2023. He submits that, therefore, in the written note prepared by the investigating officer under heading ground of belief, the statement made by him that due to lack of time he could not obtain search warrant is not believable. Stop. Learned counsel for the appellant has further submitted that in the instant case, the examination of the appellant under section 313 of the Code of Criminal Procedure was not properly done by the trial court. He submits that during the said examination, the appellant was, where is 313?
Lordship.
Page number 313. 18. He submits that during the said examination, the trial court put only one question wherein entire accusation made by the prosecution side against the appellant was put to him without specifying as to which witness have deposed against him. He further submits that the trial court also could not put questions regarding the place from where regarding the place and manner from where the seized contraband was recovered. It had only asked that the appellant had possessed and transported 42 soap cases containing brown powder suspected to be heroin. He submits that which judgment of 313?
Lordship, Rajkumar, Threat Shuman versus NCT Delhi, Lordship. Paragraph 16, Lordship. 16.1. Sixteen, Lordship.
No, 16 is something else.
Lordship, in Rajkumar versus State of NCT.
You give me your. Rajkumar Singh. Return this one. Return it back. Return it back. This was wrongly. What was the last line? Before that. He submits that the purpose of section 313 of the Code of Criminal Procedure is to enable the accused to get notice of the incriminating evidence against him so that he gets an opportunity of properly explaining the same. However, in the instant case, same was not done. He submits that it was incumbent on the trial court to put each material appearing in evidence against the accused specifically, distinctly and separately. He submits that same was also not done by the trial court. He submits that the apex court in the case of Rajkumar alias Suman versus NCT of Delhi, reported in 2023 AIR within bracket SC 3113, had laid down the guidelines to be followed by trial court while recording the statement of an accused under section 313 of the Code of Criminal Procedure, and he submits that same was not followed in the instant case, which amounts to a serious irregularity which would vitiate trial. As he further submits that which would vitiate trial, and the appellant would get benefit of the same, and accordingly he is liable to be acquitted. Staff Learned Counsel for the petition appellant further submits that due to the trial court has erred in ignoring the procedural lapses committed by the investigating officer, and it itself committed procedural lapse by not properly following the mandate of section 313 of the Code of Criminal Procedure. Accordingly, he submits that the petitioner is entitled to get benefit of doubt and is also entitled to be acquitted. Stop. On the other hand, Ms. Mary L. Kiante, the learned additional public prosecutor representing the state respondent, has submitted that there is no error in the judgment impugned in this appeal. She submits that the trial court has rightly reached the finding of guilt, rightly arrived at the finding of guilt of the present appellant, and considering the quantity of contraband involved in this case, has appropriately convicted the appellant with the punishment as imposed on him. She submits that as regards the objection raised by the learned counsel for appellant regarding non-compliance of the mandate of section 50 of the NDNPS Act 1985 is concerned, the said provision is not applicable under the facts and circumstances of this case, as no personal search of the appellant was conducted in this case. She submits that section 50 is applicable only when personal search of the accused is made. However, in this case, the contraband was recovered from the belongings of the appellant, which was kept there inside the vehicle in which he was traveling. Stop. She further submits that though the trial court did not rely on the testimony of Caesar witnesses, testimony of independent Caesar witnesses, there was sufficient material on record for the trial court to arrive at the guilt of the appellant basing on the testimony of the investigating officer as well as the first informant. She submits that the trial court has correctly relied on the ratio decidendi in the case of Kashmiri Lal versus State of Haryana within bracket Supra, in as much as the apex court has clearly laid down that the evidence of police cannot be viewed with distrust every time, and even in the absence of independent witnesses, the court may arrive at conviction of the accused if the testimony of police witnesses are found to be reliable and trustworthy. Stop. She further submits that as regards objection of not following the mandate of section 313 of the Code of Criminal Procedure by the trial court is concerned, the appellant was given sufficient notice of the incriminating evidence appearing in the testimony of prosecution witnesses in the question number 1 posed by the trial court to the appellant, in as much as it had, in the said question, the trial court has clearly stated that stated regarding the quantity of contraband which the petitioner was possessing at the time when the search was made. She further submits that the prosecution side has established the foundational fact in the instant case which were necessary to shift the burden of proof under section 54 of the NDPS and NDNPS Act 1985 to the appellant, and the appellant in this case has not adduced any defense witness to relieve that burden. Hence, she submits that the impugned judgment should not be interfered with by this court in this appeal. She further submits that the investigating officer as well as the first informant in their testimony have categorically stated that the seized contraband, that is, how much heroin was there?
512 grams.
That is 512 grams of heroin was recovered from the possession of the present appellant. Anything else?
That
Which I-
pretty much covers it, Your Lordship.
Huh?
That is all about it.
Okay. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Trial court records are there, including the records of the trial court. I have also gone through the rulings cited by learned counsel for the appellant in support of his submissions. Reserved. The hearing heard so and so. Hearing concluded, judgment reserved.
Highly obliged.
Keep the citation in a separate file. उल्टा करके फाइल एक रिवर्स साइड inside it in a separate file. Yes.
Item 12.
May it please Your Lordship, due to time constraint, if the matter may be taken up last week of February, my Lord.
Yes. Suggested date, Michael. Heard Miss, this is item number? Sure. Heard Miss Valentina Laldenpui, learned counsel. You are amicus?
Yes, my Lord.
Learned amicus curiae appearing for the appellant. Also heard Miss Vannesyami, learned additional public prosecutor as well.